We're going to have our first panelist, Sara Polinsky. And I'm not going into long-term introductions because you all have that in your packet, okay? So thank you.
Okay. Good morning, everyone, and thank you for coming today and giving your time to come and receive the information that we're presenting. I'm an estate planning and elder law attorney, and I've been practicing in that area for now 13 years. And as part of my practice, I facilitate some free legal clinics at some senior centers throughout the community. And in thinking about how to present my information, it's just what I found over the years is that the same sort of questions with respect to legal issues keep coming up. No matter how much information is out there, no matter how much literature is out there. So the most common question I always get is, what is the difference between a will and a trust? A will is made for probate. And on a daily basis, I have people who call me or come and see me who will swear up and down that since they have a will put together, that they've done everything they need to do and it's not going to be subject to probate, and that is not true. A will is made to be enforced by a judge, and it will have to be probated if you have assets that have to change title. I'm going to get there. I promise. A will is also only valid at death. So whereas a living trust can take effect during your lifetime if you become incapacitated, an executor of a will has no authority to act if you're alive and incapacitated. That's another big misconception, that people think that if they've named an executor, they don't have to do anything else. So if you only have a will and you become incapacitated, you're going to have to go through a conservatorship proceeding with the courts. I will explain that later also. Probate or trusts, one of the misconceptions is that trusts are for rich people, and that's not true, because probate is not about the value of your estate. Probate is about the title of your assets in your estate. So in California, if you own real property that's worth $20,000 or more, it could be subject to probate if it's not in a living trust or titled in some other way. If you don't have real estate but you have liquid assets that have a combined value of about $100,000 or more at the time of death, those may be subject to probate if they're not in a trust. So you can see that the estate values that we hear about sometimes have nothing to do with the probate limitations of what has to go through the courts. Can I ask you to hold your questions? I promise if I don't get to it now, we're going to have a question and answer session at the end. After the break, there's going to be a question and answer session for all of us, and we'll be here. And I promise your question will get addressed. There are some exceptions to probate, that even without a living trust, if you have these types of assets, they're not going to be probated. Life insurance policies, annuities, retirement accounts, you name beneficiaries on those types of financial products. So you have a contract with the company that if you pass away and something is left, it will pass to your beneficiaries by contract without having to go through probate. The problem, again, though, is if you have no other documents, no one can access those funds if you become incapacitated. If a withdrawal has to be made from a retirement account and you're not competent and you don't have a power of attorney, no one can do that for you. So a will by itself is not enough. Having the types of assets where they won't go to probate simply isn't enough. Having, at a minimum, a financial power of attorney if you become incapacitated, a medical power of attorney, is very important, because that's what's going to protect you while you're still living, so that you can designate the people that you trust to make those important decisions for you. If you have real estate that's worth $20,000 or more, or the higher value accounts of a combined value of $100,000 or more, you should have a living trust, because that's what's going to protect those assets from going through probate. One of the other common exceptions to probate is property held in joint tenancy, because there's a right of survivorship, and that's a very common way that people hold title and avoid probate. The problem with joint tenancy, though, is that it disinherits heirs. So sometimes, if somebody is widowed and then they put one of their kids on as a joint tenant to avoid probate, if they have other children, they've disinherited all of those children. Because no matter what you have written down in a will or a trust, joint ownership of a house, of a bank account, of an investment account supersedes everything else. And joint tenancy has some tax consequences where if a jointly held asset is later sold, there's a greater chance of having to pay capital gains tax versus when people inherit everything from a trust at the time of death. There's a increase in the inheritance value so that there's no tax that has to be paid for the beneficiaries. So those are the big differences between a will and a trust. The powers of attorney do not take the place of either a will or a trust because they are planning during your lifetime to protect yourself with incapacity. A lot of people today already have documents in place, but I want to tell you that your documents are only as good as your current circumstances. Trust law in and of itself doesn't change all that often, but your circumstances do. So if you've designated people as your trustees or your agents who have passed away, who have moved away, who you no longer have a relationship with, it's time to take a look at your paperwork to make sure that the people who are going to be acting for you and receiving things from you are the people who are representative in your life today. The other aspect of what I do is long-term care planning. So as my own clients age and as our general population ages, I work with families when they start coming across issues of long-term care health problems. And paying for long-term care is very challenging today because it's very expensive and not everyone has had the opportunity to plan in advance. So long-term care insurance is one way to pay, but if you can't afford it or you can't qualify for it, then it's not an option for you. Benefits from the VA for wartime veterans is a way that can help pay for in-home care, assisted living, boarding care, and that's something to look into because a married couple can get almost $2,000 a month of assistance for long-term care. And a single vet about $1,600 and the widow of a vet about $1,000. And that's a significant help to cover long-term care expenses that people don't know about. There is financial criteria, but the most important thing I will tell you about the VA is you must have discharge papers. So with what Jeanette was saying about the list, very important to pull together if you are a veteran discharge papers. You will not get a benefit without that piece of paper. Marriage certificates. If spouses and widows are ever claiming benefits from the VA, you have to prove your marriage to the vet. So another very important document to dig up and keep together. And the other program that I help people with is the Medi-Cal Long Term Care program. It was a program created specifically to help pay for the high cost of nursing home care. And it's not the same program as regular Medi-Cal. It was created specifically for nursing home care because the costs are so high and can really dwindle in a state very quickly. The resource limits, particularly for married couples, are much higher than you would think that they are. Congress has, when they enacted the laws, they wanted to protect the spouse of an ill person who has to go into a nursing home so that they wouldn't become impoverished as a result of a serious illness. So there's a lot of protections built into the regulations. Very important, other documentation that you want to pull together, proof of citizenship, birth certificates, copies of passports even if they're expired, certificates of naturalization. You can't apply for benefits if you can't prove your citizenship, and a lot of times I have clients with dementia or no one knows where their documents are. So keeping that important paperwork together with everything else you have could really be helpful in the future if you need benefits. How am I doing on time?
A minute more.
Excellent. So the main thing is to plan ahead because even though you may not need long-term care now, you may not need to apply for the VA or the Medi-Cal program now, you want to make sure that powers of attorney and trust documents and everything that you have, if you can't do it, that they will empower the person you trust to do it for you, so that you're not removing the possibility of getting assistance in the future to pay for long-term care. So it all really ties in together to plan for incapacity and to make things easier for yourself and your family. Thank you.
Thank you.